Nobody tells you that the most dangerous moment in a marriage isn't the fight. It's the silence that comes after the fight has already been decided. When one person in the room has already closed the file, and the other one is still sitting at the table thinking there's something left to discuss. My name is Gerald Caulfield. I am 64 years old. I live in Columbus, Ohio. I have lived in the same house on Deerfield Court for 33 years. A 3-bedroom colonial with a detached garage, a side yard. I have never quite gotten around to landscaping the way I always said I would, and a kitchen window that faces east. On a clear morning, the light comes through that window at a particular angle and lands directly on the kitchen table. I mention this because the kitchen table matters in this story more than almost anything else in it. I am a retired civil engineer. 31 years with Franklin County Public Works before I stepped back at 61. Before that, 4 years at a small private infrastructure firm downtown. Before that, Ohio State on a partial academic scholarship, studying structural and civil design, which is a formal way of saying I spent my 20s learning to understand what holds things up and what, under specific conditions of stress, makes them fall. I did not know how broadly applicable that education would turn out to be. I drive a 2011 Honda Accord, gray, 147,000 miles. My daughter has been suggesting for 2 years that it is time to move on. I find the suggestion very easy to ignore. I want to begin by telling you something about Patricia, because she deserves to be understood as a full person before I describe what happened between us. I have found that stories told without that effort tend to produce satisfying villains and very poor explanations, and I am not interested in villains. I am interested in what actually happened and why. Patricia and Caulfield, née Holloway, was a senior partner at Holloway and Crane Family Law on South High Street, downtown Columbus. 22 years at the firm in total, 16 as a named partner, the firm having been built by her father, Edward Holloway, from a 2-attorney practice above a sandwich shop near the State House into one of the more respected family law practices in Franklin County. She was, by any fair accounting, very good at what she did. She had a particular kind of intelligence that was linear and precise and largely unmoved by sentiment. She could read a financial disclosure statement the way most people read a restaurant menu, quickly, accurately, with immediate conclusions drawn and held firmly. She was 62. She had dark hair gone silver at the temples, which she wore pulled back on workdays and loose on weekends. She had her father's posture, straight-backed, chin slightly elevated, the carriage of someone who has been taken seriously in professional rooms for a long time and has come to expect it. She had earned that posture. I want to be clear about that. We had been married 33 years when she filed. Our daughter, Renee, was 31 and living in Cincinnati with her husband, Marcus, and our 2 grandchildren, Lily, who had just turned 6, and Owen, who was 3. Our son, Douglas, was 28, in Seattle since graduate school, working at a software company whose product I still cannot fully explain despite his having described it to me for separate times. Both of them had known for a while that something was wrong between Patricia and me. Children almost always know before the parents think they do. They are simply generous enough not to say it directly. What had been wrong was not dramatic. I want to be precise about this because I think the absence of drama is actually the harder thing to explain. There was no single incident I can point to, no defined moment of betrayal, in the way stories usually require. What there was, across roughly 8 years, was a gradual recalibration on Patricia's part, a quiet revision of the verdict she had reached about who I was and what I represented. She had built something genuinely significant over the course of her career. The clients, the firm, the professional standing, the dinners where her opinions carried real weight in rooms full of serious people. All of that was real, and all of it was earned. And she would come home from those rooms to Deerfield Court, and I would be in the kitchen reheating soup or in the side yard considering the landscaping I still hadn't started, or sitting at the kitchen table with the crossword I did every evening after dinner. And I think that contrast, over time, accumulated into something that felt to her like a conclusion. Her world had expanded significantly. Mine had, in her reading, stayed exactly the same size as the day she left in the morning. She was not entirely wrong about that observation. She was entirely wrong about what it meant. The first time I clearly noticed a shift was a Thursday evening, in early November of 2017. A firm dinner, their annual client appreciation event at a restaurant downtown. I can never remember the name of dark wood, heavy menus, the specific quality of conversation that exists in rooms where everyone present is carefully and continuously managing their impression of everyone else. I was seated next to a man named Frank Aldrich, a senior associate at the firm, mid-40s, the particular kind of confident that mistakes fluency for substance. He asked me, pleasantly enough, what I did. I told him I was a retired civil engineer, 31 years with Franklin County. He nodded the way people nod when they have already mentally filed your answer and are composing the next thing they plan to say. Patricia was across the table. I saw her notice the exchange. I saw something cross her face, not contempt, not precisely that. Something more like discomfort, the specific discomfort of a woman who has decided, in some internal courtroom of her own, that the evidence is already in and the verdict has been written, and who finds it faintly embarrassing to have that verdict confirmed in public. I drove us home that night in the Accord. She was quiet. I did not push. I made coffee when we got in, black, no sugar, the same way my father drank it, and I sat at the kitchen table for a while after she had gone upstairs. I thought about several things that night. I thought about the 33 years on Deerfield Court. I thought about Douglas in Seattle and Renee in Cincinnati. I thought about a conversation I had had 6 months earlier, on a Tuesday afternoon in March of 2017, with an attorney named Donald Marsh in a small office, above a dry cleaning shop on Brighton Road, about 8 minutes from the house. Donald Marsh was 67 at the time, semi-retired, a compact and very quiet man with wire-rimmed glasses, and the unhurried manner of someone who has spent 35 years in estate and asset law, and has seen nearly every configuration of human financial behavior there is to see. He had been referred to me by my older brother, Carl, who had used him for a business matter 3 or 4 years prior. Carl's entire description of Donald Marsh was 2 sentences. Doesn't waste words. Does the work. I had gone to see him because of something I had not told Patricia. I want to be careful here about how I characterize this, because I am not interested in making myself sound more strategically prescient than I actually was at the time. What I was, in the spring of 2017, was methodical. I approached the situation the way I had been trained since my 20s to approach problems. Identify the load-bearing elements, understand where the stress is likely to concentrate over time, and build the structure accordingly before the load arrives, not after. The load-bearing element in question was a company I had founded in 2003. I was still at a private engineering firm downtown at the time, and I had set the company up in Infrastructure Consulting LLC, operating under a family trust structure in my mother's maiden name. Crestfield quietly, deliberately, and without discussing it with Patricia, not as an act of deception. I want to be precise about that distinction, because I think it is important. It was an act of construction. I had seen, in the years I spent doing engineering work, what happened to structures built without adequate foundations. They performed well enough in ordinary conditions and failed under load. I was not willing to build my financial life that way. Crestfield Infrastructure Consulting had started small. A secondary income one could, in 2003, accurately described as modest. County subcontracts, small municipal work, the kind of infrastructure consulting that does not attract attention because it is not glamorous, and the people who need it are governmental entities with procurement processes and 18-month timelines. I had run it alongside my county work for years, and then after I retired, I had given it more time, and had grown in the way that methodical, unglamorous businesses tend to grow when nobody is paying attention to them. Steadily, without drama, compound interest low. By the time I sat down with Donald Marsh on that Tuesday afternoon in March of 2017, the Crestfield Trust held assets that made Patricia's working assumptions about my financial position, assumptions she had been operating on for our entire marriage, assumptions I had never corrected, assumptions she had never thought to question. Spectacularly, comprehensively incorrect. Donald Marsh listened to me for about 45 minutes that first meeting. He asked 9 questions. He took 3 pages of notes on a yellow legal pad in handwriting that was small and perfectly even. Then he set his pen down, folded his hands, and told me exactly what he thought should be done and why. He used 94 words to do it. I counted because I count things. It is a professional habit. The document he drafted was 1 page. Single-space, precise language, notarized on a Tuesday, filed with the appropriate county office on the Thursday of the same week, March 16th, 2017, at 9:41 in the morning. I drove home on Brighton Road, afterward in the Accord, patted the dashboard at the light on Livingston Avenue, the way I always do, stopped at the grocery store, made dinner. Patricia got home at 7:15. We ate. She talked about a case. I listened. I asked 2 questions. After dinner, I did the crossword. She read briefs at the table across from me. The light from the kitchen window had been gone for hours by then, and the overhead fixture cast everything in its particular flat yellow. That was March of 2017. Patricia filed on September 9th, 2023. 6 years and approximately 5 months between those 2 events. Give or take. In that interval, I had continued to run Crestfield, continued to drive the Accord, continued to do the crossword every evening. I had also, during that interval, continued to watch, not with malice, not with the anticipatory satisfaction of a man waiting for his moment, simply with the clarity of someone who had done the structural analysis and understood at a load-bearing level where the stress was going to concentrate. She told me on Saturday, September 9th. I know the date precisely because Renee had come up from Cincinnati that weekend with Lily and Owen, and the children had been in the side yard that morning playing the leaves that had come down from the oak tree. It had been a dry September, and the oak had started turning early, and I had been standing at the kitchen window with my first cup of coffee, watching Owen attempt to throw himself into a pile of leaves that was not quite deep enough to justify the ambition he was bringing to it, and I was smiling about that. And then Patricia came downstairs in her work clothes on a Saturday. That was the first signal. She sat down across from me at the kitchen table. She placed a manila envelope on the surface between us. She did not slide it. She set it down with a specific, deliberate precision, the kind of placement that communicates, without any words being required, that the person placing has thought carefully about this moment. She said, "I've had papers drawn up. I think we both know this has been heading here for a while. Gerald, there's no reason for any of this to get ugly." I looked at the envelope. I looked at her. I said, "Okay." She spoke for several more minutes. She was composed, measured, using the tone she used in professional context when she was being fair to someone who had less information than she did the tone of the senior partner explaining the terms. She told me she had engaged a colleague at an outside firm to handle her side, appropriately, to avoid any conflict with Holloway and Crane. She told me the framework was straightforward. The house would be listed and proceeds split. Retirement accounts per Ohio statute. Her partnership interest at the firm, which she explained had been structured in a way that made it substantially non-marital, would of course remain hers. I would receive the Accord and whatever was currently in our joint checking account. She said, whatever's in that checking account, with the specific lightness of a person mentioning something that is too small to warrant particular attention. Not unkindly, but with a completeness that told me, quite clearly, that she had already closed the file. Lily knocked on the back door at that moment, holding a leaf approximately the size of her own torso, extremely proud of it. I got up and opened the door, and she held it up with both hands. I told her it was an exceptional leaf. She agreed. I told her to go show her grandmother. Patricia looked at the leaf and said it was beautiful. She was not wrong. It was a very good leaf. After Renee took the children to lunch, I sat back down at the kitchen table and opened the envelope, all 14 pages. I read them carefully, the way I read every document I have ever been asked to sign or consider, start to finish, margin to margin, no skipping. I have read a considerable number of legal documents over the course of my adult life. Engineering contracts, county procurement agreements, the Crestfield Incorporation papers, the trust instrument Donald Marsh had drafted on Brighton Road 6 years prior. Patricia's team had done clean, competent work. It was a well-built agreement. It was constructed on a specific and coherent set of assumptions about my financial position, every one of which was reasonable given what she knew, and every one of which was wrong. I set the document down on the table. I made a pot of coffee I didn't need, my third of the morning, which my doctor would not have endorsed. I stood at the east-facing window for a while. The oak tree in the side yard was doing nothing in particular. The light was coming through at that angle. It was 1:19 in the afternoon. Something in me settled into a quiet I had not felt in some time. Not anger. I want to be honest about that, because anger would have been the easier and perhaps more understandable response to what she had laid in front of me. Not grief. Exactly. Though the grief was present somewhere underneath, as it would be after 33 years of something that had been genuinely real for most of its duration. What settled over me was cold and still and absolute, the specific kind of quiet that comes when a decision has already been fully made, and your conscious mind is simply catching up to where the rest of you has been for a while. I called Carl at 1:34 that afternoon. He picked up on the second ring. I told him Patricia had filed. He was quiet for 3 or 4 seconds. Then he said, "You want me to call Donald?" I said, "I'll call him myself." Carl said, "Okay." One word. That is one of the things I have always valued about Carl. I called Donald Marsh at 1:41. He picked up on the fourth ring, which for Donald constituted something close to urgency. He sounded unsurprised, though in 47 years of knowing people who work with legal documents, I have found that the good ones almost always sound unsurprised, not because they predicted a specific event, but because they understand a range of human behavior and very little falls outside it. I told him Patricia had served papers through outside counsel. He asked me 2 questions. I gave him both answers. He said, "Monday morning, 8 o'clock, bring the full document." I said I would. I went back to the kitchen table. I looked at the 14 pages. I looked at the window. I looked at the Accord in the driveway. I almost felt sorry for Patricia's attorneys. Almost. I should tell you, before I go further, about the specific document Donald had drafted in March of 2017, because understanding what it was and what it did requires understanding something about how trusts and asset structures work when they've been built carefully and over time, and not for the purpose of fraud, but for the entirely legitimate purpose of ensuring that a man's life's work is held in a structure that reflects what it actually is. The Crestfield Infrastructure Consulting Trust was, by September 2023, a 20-year-old operating entity with a documented history of county and state contracts, a small permanent staff of 4 people who had been with me in various capacities for years, and retained earnings that had been systematically reinvested and structured. The document Donald had drafted in 2017 was a single-page instrument that clarified and formalized the trust relationship to my personal estate, specifically the premarital character of the founding capital, the continuous operational history predating any marital contribution claim, and the structural distinction between the trust corpus and any jointly held marital assets. 1 page. The kind of document that does almost nothing visible for years and then, in the right circumstances, does everything. Donald's office on Monday morning, September 11th, was exactly as I remembered it from 6 years before. The same framed survey maps on the wall. He had spent time early in his career doing county land work, and had kept a few as what I assumed was a form of professional nostalgia. The same 4-drawer gray metal filing cabinets along the south wall, the old kind with the heavy pulls, and the satisfying thunk when they closed. The same compact, deliberate presence behind the desk, glasses pushed up on his forehead, yellow legal pad already open. His coffee was in a mug from a hardware store that had been closed for at least 15 years. I have always found that detail reassuring. He had already read the 14 pages. He set Patricia's document to his left, his way, I had learned, of indicating that something has been fully processed and is no longer the primary subject. He folded his hands on the desk. He said, "Their financial disclosure request will come within 30 days. Standard form. When it does, we respond fully and accurately. Every line." I said I understood. He said, "They are going to be surprised." He said it the way a man describes weather. A factual observation. No pleasure in it. What followed over the next 11 weeks was, from my perspective, something I found genuinely satisfying to watch in a way I have always found well-executed structural engineering satisfying. Not exciting, not dramatic, but deeply correct. Donald Marsh filed our initial response and counter-disclosures on October 4th. He requested Patricia's complete partnership interest documentation and the firm's financial statements for the preceding 3 fiscal years, on the grounds that the non-marital characterization she had applied to her partnership interest was not as straightforward as her attorneys had presented it. Her team objected. Donald responded with a brief, I did not fully understand the technical details of, but that he summarized for me in 2 sentences, Ohio courts have been consistent on this for 20 years. Her attorneys know that. They are posturing. Her attorneys asked for a continuance. Donald said, of course. He said it with the same flat courtesy. He said everything. He was not being generous. He was managing the timeline in a direction that suited us. I did not fully appreciate that at the time. I appreciated it later. I drove to his office 4 times over those 11 weeks. The Accord's check engine light came on in mid-October, which turned out to be an oxygen sensor. $41 at Kowalski's on Flatbush. Danny Kowalski doing the work himself because our kids have played Little League together, and he charges me his cost on parts and does not charge labor, a fact I have never been entirely comfortable with and have compensated for by bringing his crew lunch every time I go in. I mention this not because it is relevant to the legal proceedings, but because it is relevant to the kind of life I was leading during those 11 weeks. The same life I had always led. The Accord, Kowalski's, coffee at the kitchen table. The crossword. I also, during those 11 weeks, retrieved from the fireproof lockbox in the back of my bedroom closet the documents that had been sitting there since 2017. The Crestfield Trust Instrument. Articles of organization. 6 years of operating financial statements, audited annually by a firm in Westerville. The county and state contract records. The single-page document Donald had drafted on Bryden Road. I put everything in a charcoal leather folder with a metal clasp that I had bought in 2003 for the original Crestfield Incorporation meeting and had used for every significant document since. I set it on the kitchen table. I made coffee. I looked at the folder. I called Donald and told him I was bringing it all in. He was quiet for a moment. Then he said, I was wondering when you were going to do that. The financial disclosure we filed with Patricia's attorneys was completed on November 14th. A Thursday at 9:23 in the morning. It was accurate, complete, and thorough. Every asset correctly valued. Every account fully declared. Every holding. Every contract structure. Every trust instrument. The Crestfield Trust, the operating accounts, the retained earnings, the 6-figure county contracts currently active, the state infrastructure consulting agreement that had renewed automatically in August. All of it laid out on paper in the flat. Specific language of financial disclosure. The joint checking account Patricia had mentioned at the kitchen table in September had, at the time she mentioned it, held $14,340. The Crestfield Trust held, as of the November disclosure date, assets that I will not state with full precision, because those numbers are private, and this is not a story about numbers. I will tell you that they were significantly in excess of $14,000. I will tell you that Patricia's assumption, the assumption she had been operating on for the entirety of our marriage, the assumption that had produced the easy confidence with which she had slid that envelope across the table, had been incorrect by a margin that made the word incorrect feel inadequate. I was at home when Donald called. I was at the kitchen table, naturally, coffee in hand, 9:47 on a Thursday morning. The light was doing what it does at that hour, coming in from the east at that angle, landing on the table exactly where it always lands. Donald called at 11:06. He said, they've asked for a recess. I said, how long did they ask for? He said, 3 weeks. I gave them 2. I said, that sounds right. He was quiet for a moment, which from Donald constitutes something close to reflection. Then he said, Gerald, they are going to want to settle. I said, I know. He said, do you want to settle? I sat with that for a moment. I looked at the light on the table. I thought about 33 years on Deerfield Court. I thought about Renee in Cincinnati and Owen in that leaf. I thought about the dinners with Patricia's firm colleagues and Frank Aldrich and a particular expression that had crossed Patricia's face in that restaurant in November of 2017. The expression of a woman who had looked at a man she had shared a house with for 27 years and rendered a verdict about him without asking a single question. I said, fair is all I ever wanted. Fair is fine. Donald said, I'll tell them that. A pause. You should know. She's going to understand, when this is done, that she misread the situation significantly. I said, I know. He said, are you okay with that? I thought about it. I said, I have been okay with a lot of things for a long time, Donald. One more isn't going to break me. He said, no, I don't imagine it will. The settlement conference was held on December 3rd at 10 o'clock in the morning at the offices of Patricia's outside counsel, Greer and Associates. Broad Street, 14th floor, a glass-walled conference room with a view of the city I will admit was quite good. I wore gray wool slacks and a blue sweater, the good one, which Renee had given me 2 Christmases ago. I drove the Accord downtown and parked in garage on 3rd Street, the one I have used for 30 years because they still charge $5 before 10 a.m. and the attendant, a man named Clarence, has known me by name since 2004. Patricia arrived with 2 attorneys. Stuart Greer was the lead, early 50s. Silver hair, the practiced ease of a man who has spent a long time in high-value professional rooms and knows how to manage them. He shook my hand with the slightly amplified warmth that experienced attorneys deploy when they have recently discovered a situation is more complicated than they had initially represented to their client. He was not being dishonest with me. He was managing. I did not hold it against him. He was doing his job. Patricia did not look at me directly when she came in. She looked at the window. Then she sat down and she looked at the table, and then, about 40 seconds after we were all seated, she looked at Donald Marsh, whom she had never met, and then at the charcoal leather folder on my side of the table. That was the first beat. The second beat was when she looked back at the window. Something had moved across her face in those 40 seconds that I had not seen there in a long time. It was not the expression of a senior partner managing a complex matter. It was something older than that, something that had nothing to do with the law. Stuart Greer spoke first. He used the word complexity 4 times in the first 3 minutes. It is a useful word when you need to discuss a situation, without explicitly assigning fault for having failed to anticipate it. His associate, a younger woman named Claire Yates, who was visibly the one doing the technical heavy lifting for their side, made 3 specific legal arguments in the first 20 minutes that were sharp and well-constructed, and that Donald addressed without consulting a single note, each time with the flat, patient precision of a man who has thought about all of this considerably longer than they have. At minute 24, Donald turned to me and said, Gerald, do you want to address the Crestfield structure directly? I said yes. I talked for about 6 minutes. I explained the trust history, the founding in 2003, the operational timeline, the nature of the county contracting work, the annual audits, the asset composition as of the disclosure date. I explained it the way I would explain a load-bearing structure to someone who needed to genuinely understand what it was doing, not to impress, not to perform, but because accuracy requires specificity, and I am an engineer, and I don't know another way to talk about things that are real. When I finished, the room was quiet for a moment. Patricia was looking at me, directly at me, in a way she had not been for most of the past few years. I want to tell you honestly what I saw in that look, because I have thought about it since, and I think it matters. It was not anger. It was not the cold, controlled fury of a woman who has been outmaneuvered and knows it. It was something older and more complicated, and, in its own way, more honest. It was the expression of a person who has been very good at reading situations for a long time, and who was understanding, in real time and without any comfortable distance, that she had not read this one at all, that the verdict she had written in her own internal courtroom, the verdict she had been confident in for years, had been written without the relevant evidence. I did not say anything in response to that look. I did not need to. There was nothing to add. The settlement was reached on December 3rd, same day, and finalized in writing on January 17th. I will not detail every term, because the terms are private and they are not the point of the story. What I will tell you is that the settlement was fair, genuinely fair to both of us, and that when Donald Marsh shook my hand on the courthouse steps on January 17th, he said it had been a reasonable outcome. From Donald Marsh, who uses language the way a structural engineer uses load calculations, precisely without surplus, that is the equivalent of a standing ovation. I drove home on January 17th in the Accord, patted the dashboard at the light on Livingston Avenue, stopped at the grocery store on the way and bought a rotisserie chicken and a bag of coffee, the good kind, and a box of the crossword books Renee had got me started on 3 years ago. The Thursday difficulty, ones that take me 2 evenings now instead of 1, which I find satisfying in a way I couldn't have explained 10 years ago. I ate dinner at the kitchen table that evening, the light long gone by the time I sat down, just the overhead fixture and the flat yellow and the chicken and the crossword book. I called Renee at 7:22. I told her it was done. She was quiet for a moment, the specific quiet of a daughter who's been worried about her father for longer than she has let on. And then she said, "Dad, are you actually okay?" I told her I was fine. Better than fine. She said, "Good. Owen wants to call you this weekend. He found a leaf he thinks is better than the last one." I told her to tell him I had very high standards and would need to judge for myself. It is April now. 3 months since the settlement. The side yard is still unlandscaped. I have been out there twice in the past 2 weeks, once to rake, and once to simply stand in it for a while looking at the oak tree, which is beginning to come back. I have decided I am not going to landscape it. I like it the way it is, a little rough, a little unfinished at the edges. It is an accurate representation of something real, and I have developed over the years a strong preference for accurate representations over polished ones. I see Donald Marsh occasionally for unrelated matters. He is 70 now, still semi-retired in the same sense that a river is semi-moving. He is exactly the same in every room he enters, which is a quality I value most in him. He does not perform confidence. He does not adjust himself for the room. He simply occupies it, the way a well-built structure occupies its site, correctly, without apology, doing exactly what was designed to do. Some people look at a man driving a gray 2011 Accord and eating chicken at a kitchen table alone, and doing the Thursday crossword, and think they have read the whole story. They have identified the surface, and concluded they understand the structure. They are not foolish people. They are simply reading the wrong information. There is a particular kind of quiet that falls over a man when he stops being afraid and starts being patient, when he understands that the load is coming, that he cannot prevent it from coming, and that the only thing that matters is whether what he built is strong enough to carry it. I built carefully. I built over a long time. And when the load arrived on a Saturday morning in September with a manila envelope and a comment about the checking account, everything held exactly the way it was designed to hold. Patience, it turns out, is the only currency that matters in a long game. 6 years. 1 page. An attorney named Donald Marsh, who doesn't waste words, does the work, and charges less than you would think. If you enjoyed this story, join our community by hitting that like button and subscribing for more real, raw, and family-centered stories. And as always, thank you for being a part of Dad's Raw Revenge. I will see you on the next one.